May I please your lordship? Item number 12, my lord. I am no longer with this matter, my lord. I want to withdraw. My
My lord, in his place, my lord, I have been contacted by the private respondents. I have filed my wakalat number for the private respondent number 5 and 24, my lord. So far as the others are concerned, I'm yet to receive the wakalat number. So I'm praying for 2 weeks time. My lord.
My lord, in item number 11, 12, and 13, I'm appearing for the board. My lord, I'm appearing for the rubber bill. My lord, I'm just few minutes back, my lord, I'm told that they will take an adjournment and a slip has been circulated yesterday. I have not been informed, my lord. My officers have come from Kerala, my lord. Some records have come, the officers have, they have also. Correct. But because of some, the considering the seriousness of the case, my lord, they have come. My lord, the short date, I pray, my lord.
My lord, I am from the appellant, my lord. Appellant will return 30th of September, my lord. And officers was called for last occasion because positive time. Today they are present. That part may be taken after the private respond whatever. Your lordship make a query whether roster point seniority is given. That points may be, my lord. Today that part, my lord, some part, my lord, that officer will clarify. Then, my lord, that may be given.
I got.
My lord,
I got the
my lord, the urgency was there is anxiety is there, my lord. That's it repair.
next week. Let it be next week, my lord. Let it be next week, my lord.
Yes, my lord. Be sure, my lord. 7 and 24, my lord. 7 and 24. 24. I'll give the numbers, my lord. Much obliged.
Before 30, my lord, 30 September.
This is he will appear. Mr. Sharma will appear.
No. I'm not appearing for these students, my lord.
I am appearing for this, my lord.
My lord, lordship. May I pray for listing of this matter tomorrow, lordship. There is matter about, my lord, the taking of my property through auction sale, my lord, without due process of law, my lord. Please stress to it, my lord. It's already been numbered, lordship. Oblige.
May I please, as your lordship, my lord, I beg to mention a old writ appeal, my lord. It was listed on 0408/2023. My lord was pleased to direct after 2 weeks, my lord, but it has not been listed. Next week, any date, my lord. Oblige.
Lordship, I beg to mention item number 16, lordship. I seek adjournment in this matter, lordship. We have to take the fresh up-to-date instructions. Petitioner, lordship. Oblige, lordship.
May please, your lordship. Lordship, I'm praying to mention a matter for listing, your lordship. This is a review petition, lordship, and we have filed it on 2nd of September, your lordship. Very short for this involved, lordship has heard the matter, and lordship, we have agreed with the terms and conditions what has fallen from lordship. And lordship, regarding the cost part, lordship, there is no interference, lordship, and regarding that also, lordship, while argument, lordship has said, lordship has, and we are in an impression that the cost parts will be interfered. That was not interfered, lord. May I pray for tomorrow, your lordship? Very short. Lordship, if it is not in much obliged, lordship, so
Daily list for orders, item 14.
In this case, we were directed to take the steps. When our officer went there, lordship, the office was, they abandoned the office, lordship. So we have to take substitute step by publishing in it. I'll file necessary application. Lordship. No, lordship, I have not filed. If item 15, in this case, we were directed to take fresh steps on correct address. Lordship, there is a week's time to take fresh steps on correct address. Much. Lordship, actually escape my notice, lordship. I'm sorry, Lord.
Item number 17.
In this contempt case, the order passed by your lordship has been complied with, my lord.
Lordship, they have submitted lordship, the affidavit lordship, lordship. Obliged.
Item number 18.
May I please, your lordship? On last occasion, it was passed to take a dusty service. We have taken a dusty service, your lordship. Lordship, yes, lordship. No, lordship.
Then you want to take fresh steps.
The lordship
Notice
has
issued
taken,
to the respondent has not been served. Counsel for the petitioner to take fresh steps within 3 days thereafter, process.
lordship, we have taken steps, lordship. We have taken.
When? That order was passed on 20th July.
Yeah.
When did you take the steps?
Lordship, dusty service has been,
Dusty service has been effected.
yes,
All right. Counsel for the petitioner has office closed. That is a report. That is the report on post. Let's see who has received the service. Notice. BK Agarwal.
yes, lordship.
Okay. The counsel for the petitioner has filed an affidavit in proof of justice service upon the sole respondent. No one appears on behalf of such respondent despite service. Thus, let the what was the order under contempt?
Lordship, in page number.
What was the direction?
To take fresh steps and dusty, lordship. To take fresh steps and then
Oh,
dusty.
service you effected. You filed an affidavit of service.
Yes, Lord.
So we have to proceed because no one appears.
Lordship, in cause list, the name has been shown, lordship.
There's a name.
Yes, lordship.
You are appearing.
I'm sorry, Lordship, I am appearing.
All right, what do you say?
In this matter, Lordship, the direction is from single bench, Lordship. Already in single bench, total 8 contempt petition is pending. Only this single person filed this contempt petition before
The
the.
order is by single bench.
Yes,
Why the
division bench dismiss our appeal only. Lordship.
so that all right, that order merges in appeal. It can very well be considered by single bench. Division bench.
We have already filed the affidavit, Lordship, that matter is going on.
What, why you have filed in division bench? Other matters SB contempt petitions have been filed. What do you say? The petitioner alleges contempt of non-compliance. Through this contempt petition, the petitioner has raised a grievance regarding non-compliance of the directions given by this court, by single judge of this court, learned single judge of this court, by the order dated 25/10/2017, passed in a bunch of writ petitions led by WPC number 5652/2009. It appears that the appeal filed by the bank against the said order was rejected by the division bench by the order dated so and so, and hence, the instant contempt petition has been preferred before the division bench. Then counsel appearing for the sole respondent makes a statement that in other analogous matters, contempt petitions have been filed by the litigants concerned in the single bench. In this way, the matter, we hereby direct that this contempt petition shall also be listed along with contempt petition number so listed before the concerned single bench along with so and so. Give the numbers. As there is no requirement of considering this contempt petition in the division bench.
Item number 19.
Yes.
There is delay of 129 days in.
How many?
129 days, my lord.
There is a private respondent also.
Yes, my lord.
Issue notice.
My lord.
MS Bora appears on behalf of respondents numbers
1, 2, 3.
1, 2,
1,
4.
2, 3, 4.
1 to 4. Thus, steps for service on the respondent number 5 be taken within 3 days, whereafter process be issued to such respondent.
Obliged, my lord.
6 weeks.
Item number 20.
Lordship, finally, this matter may be tagged with IA number 2599, Lordship, which was registered on 11th, Lordship, and
What is that IA about?
IA in retable, Lordship.
This is delay
Yes,
condonation.
condonation petition, Lordship.
So why we need to tag the IA with another matter?
Lordship.
Tell us what is there in this this delay condonation. Who's appearing?
I am caveator this petitioner lordship, number 1.
Number 1. What do you say to delay condonation?
Casual approach, there is not elaborately discussed.
31 days only.
My
31 days only.
1 day was notice to go lordship, similar case already been notice issued.
Already-
Another case filed by the appellant on against the same judgment, notice has also been issued, your lordship. That matter be tagged along with this case. Lordship.
What is the problem in condoning the delay? Delay
Lordship,
condone, connect with so and so.
Case number.
Case number
IA 2599/23.
23.
And retable serial number 9937.
Filing number so and so. Okay, check it. Okay. Ready?
Supplementary list, item 68.
Obliged.
Wait, this is also. There's a delay of, my lord,
Of how many days?
46 days, my lord.
Who appears for the respondents?
There is no private response, my lord.
No private.
None.
Who is appearing? Any objection to delay? Delay condone. Connected date appeal be numbered and be listed for admission. Does not object for them.
Obliged, my lord.
Item number 69.
Made with the lordship.
Lord, a tender was issued by NHPC, my lord, for some erosion control measures, my lord. Now, after my lord, there was a technical evaluation, following which, my lord, the bid of the private respondent was, my lord, rejected. Thereafter, my lord, on 29/9/22, an additional document was sought for and it was supplied, based on which, my lord, he has been made now responsive. That is the case. And learned single judge has taken the view that, my lord, we have suppressed material fact. But there is no occasion of suppressing the material fact because the proceedings will be annexed in the writ petition. Please come to page 283, my lord. Page 283, my lord.
Page 2.
This is the, my lord, minutes of the TEC, Technical Evaluation Committee. Kindly mark the date 5/8/22, my lord. And if your lordship will kindly come towards the bottom, TEC duly constituted at note has gone through the technical bids submitted by the above participating bidders and has sought clarification from the bidders. The details of clarifications of the bidders' responses from the bidder is indicated below. Then, my lord, pursuant to that, if your lordship would kindly come to page 284, serial number 2, Brahmaputra Infrastructure, that's the private respondent, my lord. EPF certificate in the name of Brahmaputra Infrastructure Limited not submitted.
Not submitted. Okay.
Now, my lord, will kindly come to page number 289. Now, this is the portion where, my lord, the evaluation was made. Now, serial 3, Brahmaputra Infrastructure Limited, so and so. My lord, will kindly come to 291. Sorry, 291. They do not responsive. Page 291, my lord. Remark.
291.
Page 291, my lord.
Just
Part of the same remark, serial number 24 remark. As per above serial
techno-commercially
number,
non-responsive.
the bidder is technically commercially
Commercially
non-responsive.
Let us
After
see,
this, my lord,
let us see
Yes.
in the columns of discussion,
yes,
what has not been submitted
EP, but that employment,
in this very,
yes,
from page 289 onwards.
yes. Kindly see, my lord, so and so, as per
It is
NIT.
at page number 10, or serial number 10,
Yes,
valid EPF certificate.
yes, not
Submitted
as
in the
per
name of-
NIT. Submitted in the name of Brahmaputra Consortium Limited.
Yes.
Whereas, my lord, the bidder is Brahmaputra Infrastructure Limited. Brahmaputra Infrastructure Limited is the bidder, my lord.
Then what happens?
Then, my lord, it was technically held to be non-responsive. Thereafter, my lord, will kindly come to page number 310. And the last date of submission was 30/8/2022.
30th August.
30, yes, my lord. Now, apparently, my lord, the party has given. Kindly see, my lord, this is in reference to the above subject matter and tender submitted by you. In this connection, you are requested to submit the following document. EPF certificate in the name of Brahmaputra. Now, after the last date, where from they get the power, my lord? Now, my lord, will kindly come to page 304. Now he has been made responsive. It was
Is there
decision taken on date
any
where-
discussion?
Yes, my lord. Serial number 2. Brahmaputra Infrastructure Limited, Brahmaputra so and so. The firm had not submitted EPF certificate in the name of the bidder, that is Brahmaputra Infrastructure Limited, as required against clause number so and so. The firm was asked to submit the same. Against the same, firm has submitted EPF challan only, wherein the name,
Okay.
name of the firm is
Now, what is the difference in price bid?
mentioned.
Yeah, the price bid, this Brahmaputra has been held to be L1. Ms. Chaudhary, Brahmaputra has been held to be L1.
His bid is, my lord, 1 crore less.
1 crore. That's quite a significant difference.
But, my lord, kindly see the relevant clauses, my lord. There is no enabling provision. After the last date of submission of
All right, what the single judge says about
Yes.
your case, let's see.
Yes.
What concealment did you make?
Yes. Yes. One nine zero,
90 bit sufficient with 2%.
judgment, 52.
11 is 61.
My lord will kindly come to page 61,
61 of what?
judgment, my lord. In fact, the discussion and decision starts from para 14.
There was an earlier writ petition also. What happened in that? Oh, this is the very writ petition,
This is the.
118.
Yes.
Okay.
Kindly see, my lord, page 64, para 18. The petitioner has utterly failed to demonstrate that by granting opportunity to the 6 out of the 10 bidders to provide clarification, the document, there was any intention of the tendering authority of NHPC to favor any particular bidder. The decision taken by the TC thus cannot be held to be bad. My lord, the learned single judge's view was this clarification was sought from 6 out of the 10 bidders. Therefore, there could not have been any bad intention. But it's not a question of good intention or bad intention. Question is whether after the last date of submission of bid, any
So
clarification.
that opportunity was given to particular, all the bidders till a particular date,
6 out of 10.
till a particular date only.
Yes,
And the
Not-
rectification has been allowed thereafter.
yes, thereof.
Non-responsive could take into account.
And he was initially made
But Mr.
non-responsive.
Chaudhary, you said that you have been non-suited on account of misstatement of fact.
Yes,
Where is that?
yes. Concealment of fact.
Concealment.
Para 14, my lord.
What was the concealment?
That, my lord, the 6 bidders were, given the opportunity. My lord, that proceeding itself was annexed in the writ petition which I have read at page 283.
Who appears for the respondent? Are you appearing? For whom? Yes.
Court number 13. May I please your lordship, court of matter taken up?
Sir, matter has been taken up. If he has priority in court number 13, he is free to do so. No, we are not going to wait. This is absolutely unacceptable.
Lordship,
Discourtesy.
matter is actually going on there.
Grave discourtesy to the court number 1, sir.
I apologize, your lordship.
No, we are not passing the matter over. If he had any intention of arguing the matter, he should have been here. If he has given precedence to a single bench matter, well, he let him be there. All right, heard, take down the instant intra-court writ appeal takes exception to the judgment dated 7/9/23 passed by the learned single judge, whereby
Sir, lordship, if I may.
you may address, please. If you want, we'll hear you. We are not stopping you from arguing, but we are not passing the matter over. We have heard the matter in your presence. And once the arguments have been concluded, then you say that counsel is not here.
No, lordship, I was also in the senior advocate in that.
That is your problem, sir.
I-
Matter has been called out in routine. We have not taken the matter out of turn.
It was the last matter of the least, your lordship, we thought it will take up some time. This item number 1 was there.
That is your perception, sir. We can't help it. We have taken all the matters except hearing matters in seriatim. No, we are not passing the matter over. Takes exception to the judgment and order dated 7/9/23 passed by Leonard single judge dismissing the writ petition number 118/23 preferred by the appellant herein, seeking to question the decision of the tendering authority, that is the respond number 2 to 5 in giving an additional chance to the respond number 6 to rectify the defect in its technical bid pursuant to the tender process initiated by the notification dated so and so. The senior counsel, Mr. Chaudhary, submits that as per the notice inviting tender, the last date for filing the complete tender documents was
38/22, my lord.
30th August 22. Full stop. After receiving the tenders of all the parties, the TEC report was prepared on What is the date of this
Page
document?
281, my lord.
What is the
It
date?
was on 5/8/22.
No, 5/8/22. No, this
Sorry,
is
sorry,
not
sorry.
the date.
29,
DEC report.
No, it was given us like
29/11,
Tw-
and second report to 10/12/20.
29/11, my lord.
No. It
Yeah.
can't be 29/11.
10/12/2022, second.
No, First two.
After receiving the
29.
20
tender documents of bids of all 10 bidders, certain defects were noticed, whereupon, opportunity was given to the bidders to rectify, clarify the discrepancies. Full stop. The evaluation was made by document placed at page 283 within bracket annexure B of this appeal, whereby, the technical bid of the private respondent number 6 was declared to be defective as the bidder failed to submit the EPF certificate in the name of Brahmaputra Infrastructure Limited, which had submitted the bid. Full stop. The final evaluation made at page number
304, my lord. On 10/12/22.
Ms. Chaudhary has drawn the attention of the court to the evaluation of the bid of such respondent at page number 291 of the appeal, wherein, in the remark column, it is noted that as per above serial number 10, the bidder is techno-commercially non-responsive. It is the grievance of the appellant that subsequently, and well after the last date for filing the tenders, the NHPC, tendering authority NHPC, issued a letter dated 29/9/22, giving further opportunity to the respondent number 6 for submitting its EPF certificate in the name of Brahmaputra Infrastructure Limited. It is contended that once the respondent had been declared to be technically non-responsive, it could not have been allowed to file additional document, and that too after the last date of submission of the NIT and the opportunity to furnish clarifications. He further urges that the observation made in the impugned order that the appellant herein made had concealed material facts is also incorrect, because all relevant documents were placed on record. First up, do you have any submission to make? Please make. What was the last date for submission of the tenders?
38/20.
Submission of tenders for 38, your lordship.
30th August. And were you given an opportunity to rectify your technical bid?
Yes, your lordship.
Were you declared to be technically not responsive?
I'm appealing for NHPC.
You are appearing for the NHPC. So was the private respondent declared non-responsive?
Yes, your lordship.
And is there any scope in the NIT to extend the time for rectifying the errors in the bids?
Lordship, what is, initially, if your lordship permits me to place the fact, I have.
Yes, we are with the document. Read.
You'll find lordship, date 5/9/2022.
Yes.
Each of the 10 bidders, including the petitioner and respondent 6, were open and.
We understand, gentlemen, one opportunity was given to 10 bidders. After 6 bidders to rectify.
Rectify.
The respondent number 6 did not rectify its bid.
Respondent, here is the case, your lordship, the. Fact is, your lordship. Page number 92 of the paper.
Hmm. Uh, You mentioned at 29/11 that the mail sent, EPF challan sent by the said bidder
Yes, yes.
was omitted. Where is that email? Let us see. Is there any email to this effect? Let's see.
Could this it? Could this it? Could this this?
First, tell us what is the last date for bid evaluation as per your documents. In the NIT, what is the last date for bid evaluation?
The last date of.
14th October
was
this, eh?
38, your 38.
That was for submitting the bids.
Yes.
Evaluation.
The bid evaluation, it's a process, your lordship.
Yes. So what was the date? What is the date of this TEC report? First, let us know that. Then
29/11.
The first TC report is of.
there is a discrepancy, Mr. Chaudhary. If this is 29/11,
Yes, my lord.
then this letter which you are referring to,
Ah.
this doesn't seem to fit in 29/9. If 29/11 is this, because
First TC was on 29/11, my lord.
where is that? Where is the date of that?
Yes, last
Yes.
page.
Page 30.
Starts at, my lord, page 283.
Hmm.
and
29/11.
Yes. I'm
So now they say,
Kindly come to page 303, my lord.
yes, we have read it there. There's the date is 29/11.
Yes.
So this letter you are referring
Hmm.
is of 29 September,
Yes,
before this TEC report.
yes.
So their case is that Brahmaputra had forwarded its certificate, EPF certificate in the correct name before this date, 29/11.
No, my lord.
Yes, that's what they say.
Yes, no, before 29/11 is okay.
So then,
But no, my lord, the last date is 38.
no, but they have permitted everyone, 6 persons to rectify. If that has been done across the board, then what is
No,
the
in
Malachites?
In spite of that, my lord, after giving that opportunity also, he could not.
No,
produce.
they had, that is what the case is. That is what makes a difference. Where is that mail? Is it referred to in your pleadings? Let us see. Where are your pleadings?
আমি কৈছো 29/9 ত দিছে
That makes a huge difference.
29/11 তে হৈছে তাৰ আগতে দিছে
Because you never questioned that decision to permit 6 persons to rectify their bids.
Yes.
That decision is not under challenge.
No.
So then, till that date, if they had submitted
No,
the
my lord,
document,
even the tender condition also says there is a scope for seeking,
so that is what we are saying, that if before that date, the bidder had filed the relevant document and it was ignored, then it is a fault of the tendering authority,
Yes.
for which the bidder can't be
But my
penalized.
lord, the private respondent never appeared before this honorable God. Even-
Material, they are having the documents.
She was made non-responsive 29/11.
Where is that mail which you are referring to at 29/11?
352.
352.
352 of the paper.
Let us see.
কথাটো বুজা নাই তেওঁ কৈছে সবকে opportunity
The take number 352 is the mail sent to the appellant, your lordship. 352 is the letter that was sent to that mail. King for his power of attorney along with the copy of the resolution of the instant NIT tender, your lordship, and contractor registration certificate of class 1 issued by the government, semi-government department. Issued a document
কথাটো হ'ল
for-
তাহাঁতি দিছিল নে
Right,
কনচিডাৰ
right.
কৰা নাই এইটোৱে ক'ব।
We are not bothered about appellant. You mention here,
That's what I'm coming to, your lordship. That's.
bid of respond number 6 was wrongly declared non-responsive because due to oversight, the submission of PPF challan by the respond number 6 in the name of Brahmaputra Infrastructure through mail dated 14/10 was not noticed. Where is that mail?
The mail is at page number 354.
354. This is not the mail. This is the certificate. Your case is that the mail was received before the report of the TEC.
Yes,
So where is that mail?
October 14, 2022.
My goodness.
You should find on the right hand corner, page number 354.
354.
Yes, sir.
প্রক্রিয়াটা বলে ভুল হয়েছে কোর্টেরও বিচারিত যে আমি বলছি যে 29 নাম্বার আমি দিছি বিচারিত
Yes,
actually 20
14th October.
yes
That document was sent.
no my lord
Yes, sir.
kindly see my lord on what date it was asked for
29th September. Yes.
13 10
No, 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 no.
351 my lord
29th September, Mr.
please come
Chaudhary.
to page 351
Yes,
yes what is kindly see the date my lord
351. Yes.
13/10/22
Yeah, all right.
Yes.
So on the very next day, they responded.
no I am not on that my lord
Then-
how can they do after 38/22
This is before the TEC evaluation clarification sought. That report is of 29 November. You never objected to that.
No, why should I? Because he was made non-responsive and I
No,
was made
Mr.
responsive.
Chaudhary non-responsive for the reason
Huh.
that his document was ignored.
No, my lord, my point is totally different. My point is after 38/22, how can the employer ask for any
You
clarification?
yourself said that NIT says clarification can be sought.
But before the last, I'm showing the clauses, my lord.
Yes, let us see.
Yes,
All right, let us see.
yes, that is the case. Yes. My lord will kindly come to clause number, page number 118.
Yes. Let us see the clause of clarification.
Yes, that's what I'm coming, my lord.
118.
Yes, 118, 8.1. Before the deadline for submission of bid,
Hmm.
employer may for reason, whether at its own initiative or in response to a clarification requested by prospective bidder,
Hmm.
modify the bidding document by issuing addendum.
So this is not
No,
modification
I'm
of the
coming, my
bidding
lord. I'm
document.
just showing the provisions.
Yes.
Then my lord will kindly come to page number 123.
Hmm. Yes.
16.4. Any alteration, modification in bid or additional information supplied subsequent to the bid after period of bid submission, unless same has been expressly sought for by
Sought
the
for by the
employer,
employer.
shall be, this is, no, I'm reading it.
Hmm.
My lord, come to
This-
18.1.
Hmm.
After submission of bid, the contractor can resubmit revised bid any number of times,
Hmm.
but before stipulated deadline for submission of bid. Then my lord will kindly come to 18.4.
Hmm.
No bid shall be withdrawn, modified, revised in interval between the bid submission deadline and expiration of the bid validity period specified in the bid document. Withdrawal or modification of a bid during this interval will result in bidder's forfeiture of its bid security and further bid shall be considered non-responsive.
Yes.
Then my lord, the most important is that my lord, page number 125.
Hmm.
Sorry, please come to 124, my lord.
Yes.
Oh, sorry, my lord, I failed to bring to lordship's notice one clause, clause 17 at page 123 for a moment. Online submission of bid will not be permitted on portal after expiry of the submission and the time, and the bidder shall not be permitted to submit the same or by any other mode. Similarly, hard copies of the offline documents, if received by the employer after deadline for submission of bid prescribed in the bidding data, then it will be considered as a late bid, notwithstanding the fact that the bidder has uploaded the bid online within the stipulated deadline.
Mhm.
In such a case, the stipulated.
That is the hard copies to be submitted
Yes.
by the last date.
Now, most
Yeah.
important is page 124, my lord,
Yes.
21.2.
Hmm.
A substantially responsive bid is one which conforms to the terms and conditions and specification of the bidding document without material deviation or reservation.
Material
Is
deviation.
one. Kindly come to see, my lord,
Hmm.
whose rectification would affect unfairly the competitive position of other bidders presenting substantially responsive bid. Then my lord will kindly come to 21.3. If a bid is not substantially responsive, it will be rejected by the employer
Hmm.
and may not subsequently be made responsive by correction or withdrawal of non-conforming
May
deviation.
not. It is not shall.
Yes,
And then
yes,
21.4.
yes. During techno-commercial bid evaluation, employer may at his discretion ask for bidder for clarification of his bid. The request for client responses shall be in writing or email through portal. However, no change in the price or substance.
So this is not a substantive.
Substance, my lord,
No,
that
no.
itself taken
It is a
as
hypothetical
eligibility.
thing. It may have earlier had a certificate of, the certificate's date is relevant. It is not after the last date of filing of the bid.
No, my lord,
Certificate is of an
there are-
earlier date.
There are situations when pre-existing documents can be taken.
Yes,
That
so this is a
exception there.
pre-existing document.
No, my lord, my humble submission is, if the non-conformity is corrected, then my lord, it will, affect the relative
That
standing of the
discretion has
bidder.
been given to the employer. That is the discretion given by the NIT.
No, once after rejecting it.
No, the rejection was wrong. That is what we are saying. Because the document in existence was ignored. Then of
My
course
lord,
they
my
had to
lord,
rectify it.
Let us test this case from the other side.
Yes,
Supposing, my lord, his bid was not accepted, sorry, not accepted. If he would have filed a writ petition.
yes, definitely he would have been correct in saying, I was asked for the clarification. I sent it and they ignored it.
No, my
That
lord,
is
I
what
think-
he would
I
say.
think the view of the Supreme Court is, it is the view of the employer which should be
No, but
respected.
the employer ignored it. That is what it says. The recording in the TEC is factually incorrect, not submitted, whereas the submission is there.
My lord, he did not supply on till
He did.
29.
Yes, Chaudhary, TEC is 2911. And before that, the mail was received, which was ignored.
My lord will kindly.
Let
have a
us
look-
save a crore rupees of the taxpayers'
No,
money.
no, my lord, Ross will kindly come to page 283 for a moment.
Yes.
Page 284,
Yes. 284 not submitted.
not submitted.
This is an incorrect observation because submission is admittedly there.
Now please come to 290. VA EPF certificate submitted in the name of Brahmaputra Consortium Limited.
That was along with the bid. The rectified document was submitted before this TEC report.
My lord, was the, National NSPCL so kind to this party, my lord? He's submitting wrong document, then my lord, they want to bring him in the.
There's nothing
zone.
wrong. It might have been working as a consortium. So there was a separate EPF registration. But individually also it was working.
My lord, 13th of October.
Yes. You have not disputed that mail, Mr. Chaudhary.
No, I'm not disputing.
Then there's question. This is an error apparent on the face of the record in the technical evaluation, which was correctly rectified.
Kindly come to page 304, my lord.
Yes.
Last paragraph. During the
Yes, you
deliberation.
will have to overcome your briefing counsel's anxiety.
No, my lord. During the deliberation,
Yes.
the committee also informed that bidder Mr. Brahmaputra has submitted a document issued by EPFO Regional Office Delhi regarding change in the name of EPF registration from Messrs. Brahmaputra Consortium Limited to Brahmaputra Infrastructure Limited in the tender document for the work so and so, measures on left bank of the so and so, wide dated so and so. The committee opines to consider the same towards qualification in his tender.
Yes.
In view of the same, the firm qualifies tender conditions so and so. He recommends to consider the bid of the Brahmaputra Infrastructure Limited as responsive. My lord, one document is very decisive in this case, my lord, that it was before 3822. If that document is of pre-3822,
Let
we
us
do not know, the date is not really mentioned.
Let us see.
I
Where is
think
the
that would be also. relevant.
certificate, date of the certificate?
Yes. No, we do not have. Asan again.
Even if it's,
No,
even if
we
it
do
is,
not
so,
have that, my lord. I think they must be having.
it's filed on record.
No, I don't think it is there.
Yes. What was the page, gentlemen? What was the page of that mail?
No,
Where is the mail?
no, mail does not say about the date,
Just
my lord.
a moment.
The date of the mail, my lord, is
Page number, please.
page number 354.
August 22.
14th October 22.
So it is.
No,
beyond-
Mr. Chaudhary, come to
Sorry.
page 355.
Yes, that-
Due for the wages month of August 22.
yes. August 22 is the date of document.
On the right.
Yes.
This is a system generated challan on 15 September 22.
Hmm.
So this is well before of much prior to this.
My lord, let them produce this certificate, my lord.
All right, Mr. Tiwari,
Hmm.
let us have the original certificate.
Yes.
Very good.
Bring this. It got me. during the course of arguments, it transpires that a certificate of EPF registration filed by the respondent number 6, Brahmaputra Infrastructure Limited, along with purportedly filed, कर दीजिए, along with the mail dated 14th October 22 was considered and reckoned by the NEPC, NHPC as a valid document. Let the original document, original certificate be placed on record for the court's perusal. List on Monday.
Deep level.
Supplementary list, part matter 21 to 67.
Put this in that file. The one only.
আমার নাম্বারটা কি না? হ্যাঁ? 22. My number is 22, item number 20. My lord, yesterday I drew your lordship's attention about the fact that learned single judge's judgments and findings were in a way of a sweeping nature. That it has, my lord, roped in.
226 has a sweeping operation, Mr. Barbara.
Lordship?
226 has a sweeping operation.
Right.
No one
So-
can deny that.
So I'll
The
not.
lawyers try to invoke that kind of jurisdiction.
So meaning thereby that each case will have to be handled differently by your lordship, maybe at certain joints. The common points will be there.
Very well.
Now, my lord, today, what, and also, my lord, the allegation against me that you wrote your answers in a khata which was not printed at the Assam government press is also.
That you have shown the documents that no other documents, no other printing was done
No.
on many other occasions
No.
in the Assam government press. All right.
So if that document, my lord, through RTI, which I obtained, my lord, someone obtained, it clearly mentioned that for the APSC mains examination of 2013, which is of my lord the concern, no khata was, my lord, printed in the Assam government press. My lord, that is where I left, my lord, yesterday.
Yes.
Now, my lord, today, I say, my lord, whether it is a dismissal of a public servant or a termination simpliciter of a public sector, public servant, my lord, the concerned service and discipline rules, with its provisions, governs us, my lord, eventualities. It gives the guidelines and provides for procedural guarantee. So we have a service rule in place, my lord, the SES officers, civil servants of Assam, my lord. So let alone any police report, my lord. Even in a situation like internal emergency, like one took place after 42nd Amendment, my lord, the system never allowed any state authority to give a go-by to, number one, Article 311, more particularly the provisos to it, and never allowed any state authority to give a go-by to the service and discipline rules providing for dismissal or, for that matter, termination simpliciter. Here is a series of cases, my lord. A police report was relied on as the Bible and the Gospel by the learned single judge, by, my lord, discarding all cardinal principles and statutory provisions which should guide really and which are not beyond judicial scrutiny by your lordships. When a public servant, whether a regular or a non-regular, a probationer for that matter, who is on extended term for probation for 2-3 years, in such situation where they can be terminated by a single liner gubernatorial order without any semblance of regard, at least to the guiding service code. That is my submission, my lord. Certain principles of rule of law and constitutional statutory sanctity are still to be followed in any administrative decision making before instantly terminating a public servant, regular or non-regular. And there is a clear distinction between private employments with inherent principle of pleasure tenure, like corporate employees, determined by the private, my lord, corporate owners and employers, not necessitating any material justifiable basis for instant termination of one of its employees. Private sector. Termination, my lord, simpliciter has been provided for in various central government and state government statutes. For example, my lord, the Food Corporation India.
Online. You show them.
Only. Yes.
So there is a clear distinction between private employer and my lord, government employer. Certain difference and distinctions are always there to be followed. And so far as the termination simpliciter is concerned, my lord, it has been provided for in various parliamentary and state statutes within the meaning of Article 12, my lord. Food Corporation of India, Life Insurance Corporation of India, the erstwhile, my lord, Air India Act, which was then, my lord, under civil aviation. All such statutes, my lord, provide for termination simpliciter with a rider for a prior notice, or if you cannot give a notice, then in lieu of a notice, at least give a check of 3 months' salary. Not instant and immediately. Which the state has not done in these cases, my lord. In these cases, and so far as, my lord, the Air India case is concerned, I remember one case of 1980, my lord, Nargis, Bombay High Court judgment. One air hostess, Nargis Mirza, 38-year-old lady, air hostess, opted for marriage and then for motherhood. She was terminated overnight. And it was the first case, perhaps, the right of a woman in employment was asserted, and the Bombay High Court, my lord, set aside that particular proviso, whereby an air hostess on getting married or on getting motherhood, my lord, can be terminated instantly. Case went on to Supreme Court, and Supreme Court upheld the Bombay High Court verdict. My lord, my junior will give you the list, my lord. I am producing a written argument also. So in these cases, my lord, these cases, termination simpliciter is a provision under the 98 service rules of SCS. It is not required by a prior notice or by even a 3 months prior advance pay in lieu of such notice. It's a very drastic action taken. Now, my lord, come to Rule 20. My case, for that matter, all these cases to great extent lie here. Whereunder there are 5 situations under the rules, particularly Rule 20, my lord, this book, Lordship may take.
We have that.
Yes, Rule 20, your Lordship will find that, my lord.
We are having that.
Yes, page
You
46.
read this. Yes.
Lordship will find that there are 5 situations laid down whereunder a
ABCD.
professional can be discharged.
ABCD. Yes.
Rule 20 actually requires a constructive reading of it. I am reading, my lord, the clauses. A member shall be liable to be
the head itself is, my lord, discharged by probationer. Member shall be liable to be discharged from service A if he fails. My lord, nowadays, my lord, it should have been written, my lord, if he or she fails.
Nowadays, there is a third category also.
Yes,
So it's better, he includes everything.
I was
He
referring
is
to
all
Nargis.
pervasive.
I was referring to Nargis Mirza's case of 1980, my lord, asserting for the first time women's right in the capacity of an air hostess. If he fails to make sufficient use of opportunities given during the training or otherwise fails to give satisfaction during or at the end of the period of probation, it doesn't apply. B, if he fails to pass the departmental examination unless the governor permits him to sit for re-examination in the subject or subjects in which he failed, doesn't apply to me. Clause C definitely applies to me, my lord. If any information received relating to his integrity, age, health, character, antecedents, the governor is satisfied. Governor will have to be satisfied, and therefore obtaining the deriving the satisfaction, there will be some materials before the governor. Satisfied that the probationer is ineligible. This is one word, or otherwise unfit. This is another word. These two are crucial words for being a member of the service.
Yes.
If he fails to comply with any of the provisions of these rules, or if it is found on a subsequent verification that he was initially not qualified for the appointment or that he had punished in any incorrect information with regard to his appointment. Now, so my lord, reading clause C, which demands a satisfaction on part of the governor that I am unfit or ineligible, must have some material basis before the governor. There has to be a satisfaction based on materials, and I must be allowed to confront. If you say I am unfit, if you derive a conclusion that I am ineligible, at least to that extent, I must be allowed an opportunity to confront it. Opportunity must be given, because this calling me unfit or in it also stigmatic to me. There are dismissals, my lord, with bar to future employment, and there are dismissals without any bar to future employment. If you dismiss a person, a public servant like this, it will be putting a hindrance to any future employment, my lord. For me, all doors will be closed, and it's the question of livelihood too. So D and E are not relevant for this case. And my lord, opportunity may be necessary when I say may not be necessary. When you say that for these reasons, we have seen that you are not suitable. But if you say that you are unfit, at least I am entitled to a notice, simple two-liner notice. Now, my lord, referring to the Article 311 proviso, I will not take your lordships to 311. It has been shown time and again. Page 201 of the paper book is the state's affidavit. This is state affidavit, my lord,
Yes.
by respondent 2 and 3. Paragraph 62. I am reading on the 3 paragraphs. That in the present case, petitioner me has been discharged from service by a simpliciter order making reference under Rule 20C, which I referred to already, gubernatorial order, of 98 rules, which provides for discharge from service of professionals found to be unfit for service. The discharge cannot be held to be punitive in nature, and hence there was no question of applicability of 311.
You're reading at page number
I am reading 201, my lord, page number of my paper book.
201.
It is not telling, my lord.
There is page. Yes,
201.
para 64.
Para 62. I am reading again for a while.
Mm.
That in the present case, the petitioner has been discharged from service by a simply cited order making reference to Rule 20C of the 98 rules, gubernatorial order, which provides for discharge from service of probationers found to be unfit for service. The discharge cannot be held to be punitive in nature, and hence there was no question of the applicability of 311(2). My lord, finding someone to be unfit, declaring to be unfit by taking resort to 20C, you are simply prevented from passing any camouflaged order without having any material basis. You might have passed it with hostility. Section para 63, it is most respectfully submitted that it is always open to the state as an employer to have regard to any preliminary inquiry, including the investigation carried out by police in the present case. Such material would form the motive for discharge of the petitioner from the service and not the foundation thereof, and as such discharge order cannot be said to stigmatic in nature. Any contention to the contrary would be unsustainable. My lord, it is basically related to a unilateral and preemptive mindset to give a tag on me that I am unfit. And if it is the foundation, well then I am entitled to at least a notice. Then, my lord, I have already referred to paragraph 47 at page 322 yesterday. About other things, my lord, I say only three things. Mere detention in a PS case and then filing of a charge in the appropriate court for trial by itself and cannot legally entail it. Termination simply cited on being unfit. Well, the day service rules provide, but if somebody is rightly or wrongly arrested and detained for more than 40 hours, suspension is automatic. So the authorities could have put me under suspension, which could have been continued and should have waited for the trial, outcome of the trial. Well, you extend year after year my probation. I was even, my lord, given 1 or 2 increments during my probation period. Completion of 1 year,
Yes.
1 increment, then second year, 1 increment. It will be a different proposition altogether, whether this will be a deemed confirmation or not. This may be argued by others also, my lord, by delaying.
Whether that was a ground in the writ petition,
No, that is a
whether that was a ground in the writ petition,
great petition.
that this is a deemed confirmation.
Yes,
Okay,
by your conduct,
that we answer.
I am probationer. My abilities are tested during the first year of probation. After completion, you give me an increment, don't confirm. And then you also transfer me to different places where I worked.
Hmm.
So taking together all these things, it may mean deemed confirmation of my probation, my lord. There is sufficient scope to think that since round about that period, when the investigation, it was a, my lord, well published, perhaps it unearthed certain irregularities, you decided not to give confirmation. You decided to delay confirmation of my probation. That will also not be a bona fide action by the state authority. Secondly, suspension could have continued, like your non-confirmation of probation. So the basic, my lord, criminal jurisprudential principle is, my lord, not a police report. The German consideration should not be merely on the police officer's report. It must wait till the completion of the trial, no accused is guilty. However, unlike in criminal parlance, in service parlance, it may be the preponderance of probability instead of proof beyond reasonable doubt, which can be the grounding principle. Here also I'll say, my lord, fraud is a perception which is not based on unilateral conclusion. Criminality, it has to be tried. Service law wise also, you must give a minimal right of defense to me, even for arriving at the preponderance of probability. There I committed some fraud at some stage or the other. That was not done. Fraud has to be established. It is easier said than, my lord, established everywhere. You cannot put on a proven seal of fraud unilaterally in either parlances merely on the basis of a police report. At least that is what not the relevant criminal or service Indian laws provide for. Any revelation in the criminal police report is not the gospel and may not be the gospel. Why you hold the trials then? Suppose in 2024, I am acquitted. Who will compensate for all these miseries with regard to my service and livelihood?
We pose a question to you.
Yes.
An accused is arrested in 2010. He is convicted by the trial court and then the appellate court holds that he was falsely implicated, acquits him. Does the accused get compensation?
Yes.
Does the accused get compensation? Is there any law?
Compensation, I don't know, but reinstatement is automatic.
We are not talking of a public servant. But does he get back wages? No.
No.
That is
Naturally,
the
no.
answer to your query.
Naturally, no. No,
Then
no.
that is your answer to your, this is a system.
But
If one has to suffer the consequences, we have accepted the constitution.
So I am talking
So
about the miseries, my lord. Suppose in 2024 or 25,
Yes,
I am acquitted.
yes.
I don't know about many other. Acts.
Suppose you are convicted, then why the public should suffer by,
If I am
by
convicted,
why the public should suffer, why the taxpayers should suffer by making payment of salary
no
to such people?
No, question, my lord, is not only payment. Question is not only payment. Question is
People having such character manning public offices.
the character may not be, my lord, immediately contributed upon, my lord.
We are saying if in the event of conviction, who will bring back that public faith that a person was deciding, acting in a quasi-judicial function? The ACS officers can act as executive magistrates.
Like if the,
And a person who is tainted was discharging quasi-judicial functions.
if
Who will rectify that?
if in the criminal forum, a person, more so, my lord, a public servant is convicted, and after exhausting the remedy, even at the highest level, he stands convicted, then he will have his own peril. No doubt about that. But till then, suppose, don't take away the consideration and presuppose that, yes, it is a case of conviction. It may actually well be a case of acquittal. Suppose I am acquitted.
We are
That is
just
my,
talking on assumptions, Mr. Borora.
that is
So you raised an assumption and we raised a counter assumption.
always my.
So situation is, it can't be retrieved.
So we
It's
are
plain and
just,
simple.
I am just
So
visualizing.
this is consequence of a system which is prevailing and working fine in this country so far.
So without waiting for the trial, you
Yes,
cannot say many a things, proven fraud and all these things, my lord. That is my submission.
okay.
And as I said, my lord, there are some talks about whether we are entitled to a notice or, my lord, OD alteram partem. This is not a case, my lord, where the entire examination was declared, my lord, void, and the court, my lord, competent court has directed for a de novo examination. This is not a case. Then, my lord, no one is entitled to natural justice. There are, my lord, case laws I will give. There are, my lord, 3-4 case laws by the Supreme Court, my lord. Let's suppose in an examination hall, there are 200 students, candidates appearing, my lord, 70 of them were copying. Rest 130 may not be copying, my lord. Even then it is a case of mass copying. And then the entire examination is, then, my lord, no one is entitled. But it is a case where no such thing has happened. You have picked and choose. I'll go to extent of saying this. Certain officers and allowing some other officers to work till today. The order, my lord, is a single liner. It is a cryptic order to say that I am terminated because I am found to be unfit. There has to be a rational decision making by the process by the government, which should be reflected, and there must be some speaking order. Even though you decided not to give any opportunity to me to confront where I am unfit, at least your order should reflect. There must be some reasons, my lord. This cannot be concluded like this. And when a particular set of, my lord, service rule is silent about detailed procedural methodology with regard to imparting punishment, termination, simpliciter, the existing juristic principles, my lord, pertaining to my vested right, natural justice, right of, my lord, deemed confirmation, all these things will come into play, so far as I am concerned. Because I was roped in. I was not the one who confessed under section 164 CRPC. I was not the one who made a statement under 160, admitting, my lord, any guilt on my part. I was simply, my lord, without application of mine on to the materials on record, my lord, Learned Singh is just roped in by way of a sweeping observation. The stand of the government is self-contradictory and, my lord, self-defeating. Well, if you say fraud in getting selection and in obtaining a job by me is the reason for discharge, that is one thing. At the same time, you cannot say again that unsuitability is the reason or your fitness is the reason. Both cannot go together. Moreover, unsuitability or unfit as opposed to ineligibility is not an ingredient even under Rule 20C of the concerned service code. So with this, my lord, I say with the distinction, and these are, my lord, important distinctions so far as I stand, as compared to, my lord, other writ appellants, and in general, my lord, also these are the points, my lord, your lordship will be called upon to, my lord, adjudicate. I conclude here. I will be submitting a written objection, written argument, my lord, at the conclusion of the hearing, and, my lord, some case laws I will, my lord, put on board before your lordship, my lord. Oblige. Right.
Yes, please. Item number, Mr. Mishra. Serial number.
Appearing in item number 21 and 40. 23 and 45 today. Give 45, I'll start with 45.
Which service?
Hello.
Which service?
It's Assam Police Service, both.
We'll do it. Yes, please.
My lord, on the lighter note,
Yes.
if your lordship permit me, I'll say, it's very difficult to navigate in an overcast sky.
That's it.
And that is why I'll take this, my lord, as an opportunity to try and dispel the crowd which is hovering around the word probationer, confirmation, dismissal simpliciter, or termination simpliciter.
Termination.
Because I find that these are, I was getting confused, in fact. I thought maybe I have wrongly understood the law so far. My lord, first I'll place the facts of item number 5. It's Samira Imran.
Yes.
Now, she was appointed, my lord, as in Assam Police Service Junior Grade,
Before we proceed further,
my lord.
from what we could see
Yes.
in the file in which Mr. Borbora was addressing,
Yes,
there was an argument for interim relief. What was the order passed ultimately?
yes, the.
Can we have a copy? Because we couldn't find it
Yes,
in the file.
yes, yes, in fact, my lord, your lordship, whenever I argue, I make a paper book for.
That
convenience
experience we have had,
of your
we've
lordship.
had a good experience of that, of course.
Now, before the single judge,
Yes.
also, I had given, but unfortunately.
And I would like to share that I've had this experience when I was learning the tricks of advocacy from my late grandfather. He would always prepare a paper book for the court's perusal.
No, my lord, unfortunately, the paper book is not there. We looked for in the registry also. But then I had one extra copy.
Let's see.
And
We'll share.
if we get a copy, we time, I'll get it done and provide the second copy.
Yes, please. No, we'll read from one. There's no difficulty at all.
There is another compilation of decision that I have extra simply. Paper book 2/9.
The order on interim relief, is it a part of
Yes,
the
order, yes, my lord, that order, I'll just get the order, my lord,
Mr. Borbora, are you having a copy?
It was
I
by
have-
Honorable Justice Kotesar, if there is an interim order.
I have a copy.
No, in this appeal.
Yes, yes.
Appeal,
Oh.
the matter was heard.
I don't think.
No, I don't think there was any.
I don't
No,
think.
no. What was the fate of the prayer for interim relief? That is what we want to know. Because what we find from your your appeal 75, this is the argument at 19-10-20, bench of Justice K.R. Surana and Justice Ajit Botakur. Arguments for the purpose of interim order is concluded. What happened thereafter?
I may not have appeared.
In that case, my lord, it would have been in the order, of my lord.
Well, is there a separate IA Civil 1179? Maybe the order is in that file.
That has not, may have been rejected because that has not made any difference to the petitioners.
That's not the question. We just want to know if there is any.
Earlier round of litigation.
Yes, the order is there
Yeah.
on 20th October.
Yes.
It's a detailed order, 4-page order. This is the order. If you want to have a look at this is the order.
All right, we'll take it. It's my competition here. There we go.
Yes, please.
My lord, I'll place her appointment order, which your lordship will find at page 7. This paper book. In this paper book. Page 70, my lord, 70.
70.
Yes.
70.
As my lord, it
70.
is 70, order
Yes,
dated
Mr. This is
21st August.
Kunal Das. This is not the. This is a charge sheet, basically.
No, your lordship will keep that. I'll be referring.
Oh, you're reading from the appeal file?
Yes.
Okay.
Page 70.
Okay. Yes.
Page 70 below is the appointment order on the recommendation by the Assam Public Service Commission and upon receipt of satisfactory police verification report, the governor of Assam is pleased to appoint the following candidates to the Assam Police Service Junior Grade with effect on date of joining. If my lord will come to 24, serial number 24, Srimati Veera Imran.
Yes.
So she was appointed by this order. Your lordship will find that there is no mention in the order that she would be on probation. But nevertheless, she will be on probation for a period of 2 years. Now, as your lordship has seen, she was appointed on 21/8/2015. She completed her probation period of 2 years initially on 21/8/2017.
Where is the probation period defined?
I'll come to that. Your lordship will take the compilation that I have given.
Rules,
Rules.
we have the rules separately. Which rule would you be referring?
Yes, Assam Police rules. My lord, I have given this compilation to you.
No, we have got,
Every-
got rules separately.
Yes. Oh, okay. My lord, this compilation will be in this case because the decision, everything is there, including the rules. My lord will kindly take 15, rule 15. If your lordship will take this from the compilation that I have given, page
We have
7.
already got these rules
Correct, but
separate.
page number will match
We will,
along
we'll
with
take,
this.
all right, yes.
So rule 15 will. It's under caption probation and confirmation. All persons recruited to the service shall, except person recruited under 5(2), be on probation for a period of 2 years from the date of appointment to the service. The period of probation may be for good and sufficient reason be extended by the governor in individual cases by such period as deemed necessary. Then others are not relevant for the time.
What is provision for confirmation is 17.
17.
Let us see.
17. My lord, your lordship, I just want to pinpoint in 15(1), just 2 last lines. Period of probation may, for good and sufficient reason,
Yes.
be extended by governor in individual cases by such period as deemed necessary. So the condition which is prescribed by the rule is that there should be good and sufficient reason for extension of the promotion. It will not be automatic or as a matter of course.
Likewise, you read 17, there is no automatic confirmation also. So they,
No, my lord,
they,
there I will have, I'll, if your lordship permit me,
you
then I'll
go
come
on.
back again, but I'll go on this because there's a lot of cloud. My submission regarding clouds was on this.
That's true. That's
Now, my lord, there can be 2 situations. One is where probation period is fixed. So 2 years, 3 years, no more extension.
no more extension.
Now, if a probationer is allowed to be in service beyond the period of probation,
Which is fixed. We are talking of a
Yes.
situation
fixed.
where there is no extension contemplated.
Yes, there is a fixed period, it cannot be. Then the question arises, in what capacity is he continuing? So the Constitution bench in Dharampal case, Punjab, Dharam Singh's case in Punjab said, he can continue only as a confirmed employee, and that is how the deemed confirmation was brought in.
Right.
That 68 Dharam Singh's case, a lordship would like to see, take my compilation, my lord. I'll,
But Mr. Mishra,
my lord.
we are not faced with a situation wherein there is a fixed period of probation.
Absolutely.
The
Now,
rules talk of
now they are, and
extension,
then
so-
this is also not my case.
Yeah.
This is not my case. Now, if I
So
proceed,
you want to enrich our knowledge, we'll read them.
no, not that. My lord, my lord, I don't want to waste your lordship's time. I'll never dare to admit that. I will even try, my lord. I'll never reach your lordship's experience, my lord. So, my lord, the probation period was, there is a reason for why I'm placing this. He completed his probation on 21/8/2017.
Yes.
Now, thereafter, there was a notification. It's though
a transfer order, but it contains a stipulation that I have completed not only me, whoever were there have completed their probation.
Mm,
Your lordship will kindly turn to page 81
mm,
of the paper book, my lord.
yes. 15th September 2017.
Yes,
Yes.
81. Now, this is a transfer order.
Mm.
Your lordship will go to page 85, relevant.
Mr. Borbora referred to this.
My lord.
Yes.
I'm
Yes.
referring it for a
You
different.
are referring at page 85,
Yes.
bottom.
Your
para.
lordship, see the third one. In the interest of public service, Sri Sabira Imran APS
Mm,
is posted as Assistant Commandant 12 APN Battalion Jamguri against existing vacancy with effect from date of taking over charge. Now, your lordship will come to the bottom of this.
mm,
The above posting of APS junior grade have completed probationary period of 2 years. My lord, kindly note.
mm,
And are exempted from mandatory posting in the battalion for a period of 4 months as per memo number so-and-so, 30th/8/2004. This your lordship will find at 179, this exemption in this paperwork only. As their services are urgently required in the field, in the specialized agencies CID border, so-and-so, due to shortage of officers.
yes.
Now, my lord,
It can, Mr. Mishra,
my lord,
it can also be read as a statement of fact that yes, 2 years probationary period has been completed by
Yes.
these officers. And they are required to be posted at certain places because of unavoidable emergency situations. So this is another way of looking at the order.
why?
Of
Why?
course, you will try
Why?
to project
Why?
it in a different manner.
No, my lord.
We understand.
I'm asking a question to myself, why
Yes.
all presumptions against a person who has already been, suffering? These
We
boys
understand.
are suffering, my lord.
Hmm.
Now, there is an order that I have completed by
Yes,
probationary.
2 years.
My lord, your lordship.
It's
not only-
qualified by 2 years.
Correct. No, that is the probationary period. The
Yes,
probationary period is 2 years, which I have completed.
yes.
It cannot be a statement of fact, my lord, with due respect. Because this order, if your lordship will see,
Mm,
is passed on 15th September.
yes.
And I have completed, my lord, in August, 21 August.
Hmm.
I have completed my probation. So there is an order which says that I have completed my probation period. And if what your lordship, what has come out from your lordship, if this had come out from their side, yes, then
As you say, just because we'll have to adjudicate.
my lord, of course,
You see, the satisfaction, what argument you are formulating,
yes,
a deemed confirmation, that satisfaction of completing a satisfactory period of probation had to come from the governor. Then perhaps this argument would have
My-
held water, that the governor has concluded or recorded a satisfaction.
you-
That-
your lordship will see who has passed this.
Let's see,
The order is passed by the principal secretary to the government
To
of
the-
Assam.
government of Assam.
Yes.
Yes.
Governor himself will not pass the order.
Yeah, obviously, that will be.
So, and my lord, if your lordship again says that there is no averment for and on behalf, then my lord, that case of that one case from Bihar on Article 167 of the Constitution, is a compensation case. I'm forgetting the name.
Mhm.
But I can surely place that case. So it cannot be disputed. Once the order is signed,
Order is signed.
it cannot be disputed. So
Mm.
this is an order for on behalf of the governor of Assam.
Mm.
Otherwise, my lord, additional principal secretary, government of Assam per se will have no power.
Yeah, that's right. The order is by the government.
Why the government?
Yes.
And they say that satisfactorily, I have completed the period of probation of 2 years. Okay? I'm
Only the word satisfactory is missing.
My lord, if I have completed, it has to be satisfactory. Otherwise, they can throw me
All right.
Because, my lord, I will never dispute this proposition, my lord, that the probationer or a person on temporary employment
Mm.
do not have a right to the post. The lien is not there. Lien will be created only after confirmation. I will not dispute that proposition.
Yes,
But here, my lord,
yes.
the issue is whether I have completed. I've completed on the face of it. Anybody can see.
That is statistical fact.
Yes, but
That's the mathematical fact.
order is there. There was no need to
Even if
pass
there
it.
was no order, it's a mathematical fact that you had completed.
Correct, but on top of that mathematical fact, there is an order by the governor
Yes,
which says that I have completed my probation.
right.
Now, I can complete, if the order is that I have completed my probation, it could only be satisfactory probation. Unless Mr. Kohli otherwise advises the governor.
Yes.
Now, my lord, this is the first factor. The second factor is, my lord, that I have raised is that I was given two increments.
Mm.
Two increments. One, after completion of 1 year, and the second was after completion of my probation. As per Rule 21(1). If your lordship can kindly have Rule 21(1). And this has not been denied. There is no denial. Funny, you know.
Yes.
21, my lord, in my paper book, it is page 9.
Mm.
Increment.
Mm.
The first increment to a member of a service in junior grade time scale shall accrue on the expiry of 1 year from the date of his joining of service. But further increment due shall be admissible only on his confirmation of the service.
Mm.
Then not relevant. I will take your lordships through the pleadings
Yes.
and the reply on that.
Mm.
My lord, kindly turn to paragraph 18, page 56.
That's your writ petition.
My writ petition.
Mm. Okay. 56. Yes.
That it is stated that during their service period, the petitioner received 2 increments, and hence in terms of Rule 21(1) of the rules of 1966, their services stand confirmed. For ready reference, Article Rule 21(1) of the rules is quoted here in below. Then the rule is quoted. Therefore, it is respectfully submitted that the respondents having provided 2 increments to the petitioner, the petitioner's service is deemed to be confirmed. In that view of the matter, the impugned notification dated would not have been passed without conducting an inquiry as contemplated under so and so. Even otherwise, my lord, the case that I'm going to project, these are the facts that I'm placing before lordship. The case that I'm going to project, that the status and right of a probationer or a temporary employee was settled long back in 1958, Purushottam Lal Dhingra's case, my lord will remember, by 5 judges bench. And that has been, my lord, followed and relied upon in Samsher Singh case, that is 7 judges bench, 1974, Samsher Singh case, wherein, my lord, it is said that if a probationer is found unfit for the job, for the service, or an inquiry is conducted merely to find out whether he's suitable or he is not suitable, he is not required to be given any opportunity, his service can be discharged, can be dispensed with. But if the order of termination or discharge is based on some imputation, then he is equally protected as the confirmed employee under Article 311.
Now it's no more res integra, my lord. I will place your lordship all those decisions.
Yes.
And here, the admitted case is that it is by way of misconduct.
Hmm.
The difference has tried to be made on two counts. To say that if a misconduct relates to period before your appointment, you are not entitled. And if it is relatable after your appointment, then yes, you will be entitled, even as a probationer. That is the law which has been laid down by the learned single judge. With, my lord, all respect, this is a new proposition of law wherein there is bifurcation between pre-recruited misconduct and post-recruited misconduct. This is what has been done. I'll be placing and I'll be developing my argument on that. Now, my lord, the answer to this is given in paragraph 78, which my lord will get at page 175.
Yes, just.
Page 175. It's a long para. I'll read it, my lord, but I have not found any specific denial. Of course,
Page 78.
78, subject to correction because sometime I miss.
78
I
is
have-
not the correct page, sir.
174, my lord,
174.
174.
Okay.
The AO starts from 144, AO of the government.
Hmm.
And oh, I'm sorry, my lord, I will not say government. This, though, I should have pointed out in the beginning. My lord will kindly come to 144. There it begins. And your lordship will see at 145.
Hmm.
Affidavit in opposition filed by respondent number 2 and 3.
Hmm.
It is not by the government. Because here, the state is represented by the chief secretary
Hmm.
at page 2 of the cause file, my lord will see. So there is no affidavit by respondent number 1 by the government. So it is 2, means the secretary to the government of Assam, Home's
Home
department,
Office.
and additional secretary.
Hmm.
It is not. So
Hmm.
I don't know what will be the effect of it. Because the allegations are against the government, all orders will be against the government. My appointing authority is the government, not individual respondent number 2 and 3. So there is no affidavit.
Who has passed the order notification dated this 15th
The
September to
impugn notification
17.
is 187.
Principal Secretary to the Government of Assam,
Yes.
Home and Political Department.
Yes. So it's by the government.
Hmm.
It can't be personally, In our system of democracy, the bureaucrats, my lord, they also sign as per the policy or the direction of the minister.
Minister.
So therefore, this is not an affidavit by the government.
It is by the Secretary Home Department.
Yes.
Mr. Mishra, if you see the appointment order also,
Yes.
that is also by the Secretary of the Home.
No,
Home Department.
foreign on behalf of the governor. My appointing authority is governor,
Is the
my lord,
governor,
not the
yes.
secretary.
That's right.
And this person who has passed this order, if he passes himself, he cannot. Then I will
He
challenge.
is
him.
incompetent.
Yeah, he's incompetent. He cannot pass.
Hmm.
So this is not by the government.
Yes.
I'll place, my lord, paragraph
Yes,
78.
please carry on. 78.
Yes, contents of para 18, which I have just placed before your lordship. 18 to 20 of the writ petition are incorrect. So and so, so and so. The submissions made hereinafter above are respectfully reiterated. So and so, madam. But the only thing I would say the relevant is, number one, they have not denied. If they have denied, let them find out and show it to your lordship instead of my wasting your lordship's time reading whole thing. Your lordship will kindly come to page 75, the next page.
Hmm.
Next page.
around 5 lines from the bottom, from the
The
top.
petitioner may have
May have
completed
completed 2 years of probation, but that doesn't result in deemed confirmation in service for which a specific order is required to the, on the satisfaction of the governor as mandated by the statutory rule. No such a specific order of confirmation by the fulfillment of the conditions as stipulated in the statutory rule have been issued in the present case, and the petitioner is continuing on probation, so and so, so and so. So again, a specific order, I will show, my lord, the rules which provides for a specific order of confirmation. Because this was taken note even in Dharam Singh's case by the Constitution bench, and which says if the condition of, if there is no condition attached to the confirmation, then only he'll be deemed to be confirmed. If there are conditions, then it will not be.
Yes. What happened? UPS. Switch it off. Yes. Carry on.
इसमें नहीं है। My lord, the matter was situated thus. The petitioner was arrested in connection with the Brugger case, like all other cases. She was arrested on 8th of November 2017, when 936, in connection with 936. And thereafter, she was placed under suspension. The suspension order, my lord, will kindly turn to page 134. 134.
Yes.
Whereas a report has been received from the Superintendent of Police Dibrugarh that Srimati Savira Imran, APS Assistant Commandant so-and-so, has been arrested in connection with Dibrugarh police case number so-and-so, and added section so-and-so, which is unbecoming of a police officer. Now, therefore, the governor is satisfied that it is necessary in the interest of public service to place Savira Imran, APL, so-and-so, under suspension with effect from 8/7, the date of his arrest. Accordingly, the governor of Assam is pleased to order Savira Imran, so-and-so. Now, if my lord will see Rule 6, this is a confirmation. It will be a deemed confirmation, suspension. It'll be a deemed suspension.
On arrest, 48 hours in
Correct.
custody. deemed.
The Rule 6 is same. I need not trouble. I need not trouble your lordship. Your lordship has that because this is it.
We are having.
We have given, yes. Your lordship will see 6(2).
6(2)
of the Assam Services Discipline and Appeal Rules, 1964. I've given a copy below. You said.
Yes.
My lord, page 5, if my lord will see. A government servant who is detained in custody, whether on criminal charge or otherwise, for a period exceeding 48 hours, shall be deemed to have been placed in the suspension with effect from the date of such detention by order of appointing authority, and shall remain under suspension until further orders. So this suspension order was a deemed suspension order. Now, my lord, here these 2-3 things I would just like to refresh, my lord. Just recap. Well, at first, your lordship has seen the notification dated 15/9/2017, the transfer notification, which says that I've completed my probation. Then the second one I have shown is Rule 21. Rule
Second increment on
Second-
confirmation.
second increment is given to confirmation only. And third is suspension order. Otherwise, my lord, no, for a probationer, if such thing has come to the notice, issue a show cause notice and get rid of him.
Hmm.
Why suspension and contemplating inquiry? The inquiry was contemplated.
Role of department.
Yes. There was no need. So even they thought yes. And my lord, one thing yesterday your lordship asked when my friend Mr. Chaudhary was arguing that yeah, please. On what basis these suspension order or termination orders were issued, your lordship asked whether there was any police accused forwarding report or status report where police say these are the progress, these are the evidence for involvement. So those I have placed and I will show before to your lordship. Now, the one affidavit, in fact, the affidavit that I have placed, this was filed, no date is there. This was filed in July 2019. Before that, 11 before that, my lord, a number of affidavit in oppositions were already filed in this court. The first affidavit in opposition was filed. All these are there, my lord, on record.
We can presume.
12/12/2017. Thereafter, this was in an ACS officer. Then the second was on 21/6/2018. Third was 21/6/2018. The
In
fourth
different
was,
files.
my lord,
In different files.
yes, 9/5/2019, then 7/5/75. And this was filed in July 2019 after these. And my lord, a lot of new things were brought. But I will refer, my lord, which report was considered by the government before this affidavit was filed, because this is filed as an affidavit in opposition here. In rest of the cases, it is filed as additional affidavit. So, my lord, there is a clear stipulation that the discharge orders were passed on the basis of a police report dated 17/6/2017. And this was in the additional affidavit dated 24/4/2019. My lord, will, if your lordship will kindly take the compilation which I had filed before the single judge, learned single judge. But not additional, it is affidavit.
We are referring to.
My lord, I'm referring to this paper book which I had given before the single judge.
Yes.
My lord will kindly turn to 348. 348.
Kohli, you are having this paper book?
Yes, I had given, my lord. It was.
Actually, Lordship, I'm checking exactly that. I'm so obliged you asked. I'm checking if I have it because I'm not finding it in the immediate papers of this file. But I'll.
This is an affidavit filed in, we'll just get him.
WPC 5817.
WPC 5817,
of 2017.
Bhaskar Chandra Dev Sharma.
Yes,
Affidavit in opposition by respondent number 2 and 4.
yes.
Sardesh Sharma.
Even if you don't have the paper book, you will be having the affidavit in that file,
He can find out in his
record.
in his record, because I had given her, there's no question. of
Lordship,
mine.
I have the entire, there are about 4 bundles. I'm going through it. I'm so obliged, Lordship. Ask.
Yes, please.
Give you.
Well, my lord, kindly turn to paragraph 5 at page 349. With regard to the statement made in paragraph 6 to the writ petition, the deponent begs to state that the superintendent of police Dibrugarh, while it is later dated number so-and-so dated 17/6/2017, has reported that on 27/10/2016, complainant Dr. Anshuman Gogoi of so-and-so lodged an FIR to the effect that the accused, this is actually FIR. So this is the basis, my lord. And this we don't have. It is not that a police remand report or a status report or the charge sheet is the basis. Basis is a letter written by the superintendent of police, Dibrugarh. Where is this? If they produce it, it will, my lord, be beneficial to all.
But why do we need, this para doesn't say
My lord.
that the discharge order is based on this
My lord.
letter only.
My lord.
The
My lord,
paragraph further reads, as per the report of Dibrugarh Police.
Yes, yes, my lord,
Which
I'll
one, sir?
read out that on laws.
Factual report which we were
FIR.
referring to, Mr. Mishra.
Yes, my lord.
That is there in this para. The factual report,
Yes,
the progress report which
that's right.
we posed a
So-
query to Mr. Chaudhary.
So therefore,
Hmm.
my lord, this is the basis. This is the report that they are talking about in the order,
Hmm.
that this report they have received.
Hmm.
So we don't know. Normally, my lord, with your lordship's experience, the police report is, my lord, defined under section 3R of the CRPC, which means a report submitted under section 173 to CRPC.
Right.
This is, they have not considered on that. They considered on a letter.
Hmm.
So, my lord, all that I'm trying to place before your lordship is,
Yes.
it's not clear what was the basis for formulating that opinion that we have committed colossal fraud.
Hmm.
Because all big words have been put here. I will place, my lord.
Hmm.
We all, my lord, Mr. Kohli is, of course, he's a knowledgeable person, can put all those. So these, and your, my lord, this will be common in all, I have not seen in all.
Hmm.
They never say that we have this thing, discharge them on the basis of charge sheet. They have never said that.
Hmm.
So now, my lord, the allegations which are there against this appellant, if your lordship can turn to where is it? That allegation. Are you right, sir?
Lordship, I found the paper book. I was obliged.
Okay, charge sheet. My lord, charge sheet I have submitted in this paper.
Yes, please. Yeah.
Yes, yes. Now, charge sheet, if your lordship will take, can you see from the top how many charge sheets were filed? There are 11 number of charge sheets.
Hmm. Supplementary charge.
Yes, first, then supplementary. This is supplementary charge sheet number 10, madam,
Hmm.
which will be relevant for both the appellants before your lordship.
223.
223. Here your lordship will see at page 224, serial number 18, Sabira Imran, accused number 18 at 224. Then next page, serial number 53, accused number Ravi Sharma, accused number 53. Then my lord will go, similar allegations are there at page 231. my lord.
Yes.
In course of investigation, it is found that the arrested candidates A11 to A66 and accused 69 to 72 has appeared in respective examination, received answer script provided by the APSC authority. These answer scripts were received by the candidates in their own signature as per attendance list, and as well as signed by the invigilator on verification on the date of examination at the examination hall. The answer scripts were brought to the confidential room of APSC Khanapada and examined by the examiner as per norms and procedure and conduct of business 210 Assam Public Service Commission. Thereafter, Takesh Kumar Paul, accused number 3. Pavitra Koibatra, accused number 5, in connivance with Dr. So-and-so and so-and-so, printed duplicate answer scripts and provided to the arrested candidates accused 11 to A66 and A69 to A72 in various subjects for rewriting the answers against the examination. In these answer script, they have forced the signature of invigilator on duty and given marks by their own will to get selected in APSC illegally. In some answer script, Rakesh Kumar Paul with his co-accused has enhanced the marks as mentioned in the chart sheet. Thereafter, the original answer scripts replaced and kept the duplicate answer scripts in the confidential room of APSC office Khadapara and prepared tabulation sheets on the basis of manipulated mark sheets to adjust the candidates of their choice illegally and not on their merit. It is further revealed that Rakesh Kumar Paul, so-and-so, so-and-so, and so-and-so have destroyed and concealed the original answer script of the candidate. This is established by 161 CRPC statement, recovered answer script, forensic report, material evidence, and circumstantial evidence. So, my lord, basically, these are the evidence on which they have filed. And how this was recovered, these files, this was, my lord,
Are we supposed to go into that?
no,
that
no,
deep into the
I'm just
investigational part?
my lord, your lord, it has come from your lordship. What are the allegations? I have, my lord, in these days we have advantage. I have all the answers that your question, all the questions that my lord put. And therefore, I'm just making a passing reference because just to my lord.
Yeah, all right,
remove-
please tell us.
Yes, yes.
The basic allegation is that the original answer sheet was substituted
Yeah.
by a new one.
By new.
Yes.
And
And this fact is proved because broadly the invigilator's signatures are forced. That's
what the allegation is.
allegation.
Yes, that's what the allegation is. And my lord, one thing which actually I wanted to show to your lordship, they are referring to a statement, extrajudicial confession. And on the basis of that, these answer scripts were recovered. I don't have to say much. Extrajudicial confession leading to recovery under section 27.
So in this case,
I'm not saying.
the manner in which the recovery was effected would not be very relevant.
No,
If the signatures, if they are able to establish
Yes,
that the signatures are
yes,
forged,
yes,
that would be sufficient
My-
ground to
my lord.
conclude the guilt,
Yes,
even in the criminal trial.
my lord. I'm only on, my lord. I have just shown, I have just rather stated about that recovery on the basis of extrajudicial confession. only for the purpose that we have recently, my lord, did that case on 26, section 27 of the evidence and recovery. It has to be on police report, police statement made in custody before the police. 161 from there, whatever leads specifically to recovery, not under. And from where they have recovered, they have said from the confidential branch. That is the place where it is kept. There's no other place where the answers will be kept. So those are, my lord, in my humble submission, to create, my lord, some sort of, at that point of time, there was a lot of hue and cry, there were a lot of media, those things were there. Now I come straightway to the point, my lord, where I'll be dealing with, my lord, a proposition which your lordship is obviously against me.
No, we have not given any opinion.
At least from the, no, I'm not, I'm saying tentatively. That was a tentative view.
Yes.
I'm sure that will come, that view will be definitely come now when I place.
Yes.
My lord, on the basis of.
No preemptive strike
I-
by the
my lord,
court.
I
as
know,
yet.
my lord, that your lordship is ready to be persuaded till,
Mm.
my lord, your lordship signs the order,
Yes.
and that's kind of a good judge, my lord. My lord, on this, that we were confirmed, deemed confirmed, and that is the pleaded case. So I will just give a small reference and then I'll go to the main point. My lord, Learned Singhal just dealt with it in paragraph 55. 55 at page 291. Anipra. Page 55, my lord, the paragraph 55, 291. The judgment, my lord, cost title is very long, starts from page 232, the judgment. And the relevant paragraph 5, my lord, will get
55.
at page 291.
Yes.
The argument placed on deemed confirmation in service, either on account of having completed the initial probation period of 2 years, in some cases, or due to names of some of the petitioners appearing in the final gradation list and the word probation not being mentioned there against their names in some official documents, or the second increment having been paid to some petitioner, which increment is allowed only on the confirmation of this in terms of rule. Actually, it should have been allowed 21. The fact remains that there are no orders passed by the competent authority in respect of any petitioners towards confirmation of the service. This is what your lordship said. It is seen that in service rules, the relevant to the case law at hand, the expression satisfaction of the appointing authority has to precede confirmation in service. In singularly absent, which is singularly absent in the case. Law does not permit automatic confirmation in service due to a flux of time, unless service rule governing the service specifically lays down that condition. There cannot be any question of deemed confirmation merely on the ground of continuation of service beyond 2 years. The case law cited by Sri Singh on behalf of the state respondent on the legal principles comments acceptance by this court, a reference made to paragraph 11 of Chandraprakash Shahi, wherein legal proposition was reiterated that permanent status can be acquired only by a specific order confirming the employees on the post held by him on probation. The court also finds great force in the submission of Mr. Singh justified bona fide action of the state in discharging, removing the petitioner from service. This is in one paragraph. Now, Chandraprakash Shahi is a case which I also relied upon, but I relied upon a different proposition. Now, the Learned Singhal Judge has relied upon paragraph 9 and 10 of Chandraprakash Shahi.
11.
My lord will get at page 48 of my compilation. I'm given to my lord also. Page 48, my lord.
Yes.
My lord, as I have said, everything will depend on the service rules.
Service.
Paragraph 9, I will play. An assertion that on completion of the period of probation, the appellant has acquired permanent status is based on misreading of the provision of paragraph 541 of the UP Police Regulation. The relevant portion, it is quoted below. Now kindly see the rules. The recruits will be on probation for a period of 2 years, except that those recruited directly in the criminal investigation department or district intelligence staff will be on probation for 3 years, and those transferred to mounted police will be governed by the directions contained in paragraph 84 of the police regulation. If during the period of probation their conduct and work has been satisfactory and they are approved by the Deputy Inspector General of Police at the end of the probation period in force, the Superintendent of Police will confirm them in their appointment. Kindly see, my lord,
Yes.
the requirement. There has to be an approval by the DIG, and thereafter Superintendent of Police will confirm them. So there has to be a specific order. Paragraph 10, kindly see. A perusal of the above provision would indicate that the period of probation is 2 years. The regulation is silent as to the maximum period beyond which probation cannot be extended. In absence of this prohibition, even if appellant completes 2 years of probationary period successfully without any blemish, his period of probation shall be treated to have been extended, as permanent status can be acquired only by means of a specific order of confirmation. And therefore, the rule is there which provides for a specific order. Now, there is another case, Municipal Corporation of Raipur. This, my lord, will find in the same compilation at page 76.
Mr. Let us make it clear.
My lord.
The rule which has been quoted, that is 541.
541.
Does it refer to a specific order?
Yes.
Let's read.
If during probation of their conduct and work have been satisfactory and they are approved by the, there has to be approval by the.
All right, so let's compare
Yes.
service rules, extend service rules,
Yes,
which apply to the case at hand.
that's it.
Let's read. Rule 17.
Yes. I thought I'll go to rule 17 after citing one more.
Very good, very good. All right,
I'll-
you please,
I'll
please
quickly
carry
do
on,
it.
please carry on. Yes.
May I respectfully, Lordship, ask Mishra sir to share the citation? I'll open it on the computer.
That's Chandra Prakash Sai.
No, Lordship, the next one.
Next one is, he is still not referred to it. He is holding the ace up his sleeve. Yes. This is the next citation. That's right.
Yeah, the municipal corporation case, my lord. It is Municipal Corporation of
Raipur.
1991, 3 SCC 325.
It's referred in para 11 of this very judgment.
My lord, paragraph 7, page 76 is my lord.
76.
My-
You got the citation, Mr. Colley?
Deeply obliged, yes, Lordship.
The first question is, which is that relevant rule that would be applicable to the respondent? Admittedly, the municipal council became municipal corporation on or after August 6, 1967. A resolution was passed making draft bylaws by the municipal council on November so-and-so, exercising power under so-and-so, confirm the same under so-and-so, adopting government rules to regulate the condition of service of the officers and servant of the municipal committee, which provides thus. Your lordship will skip this, go to the rule straight away, which was government rule adopted. Rule 8. A person appointed to service or post by direct recruit shall ordinarily be placed on probation for a period as may be prescribed. The appointing authority may for sufficient reason extend the period of probation for a period not exceeding 1 year. Note, this is part of the rule, my lord, note. The lordship note, marginal notes, even marginal notes are part of the statutory rules, my lord. A probationer whose period of probation is not extended under this rule, but who has neither been confirmed nor discharged from service at the end of the probation shall deem to have been continued in service, subject to the condition that his service being terminated on expiry of a notice of 1 calendar month given in writing by the either side. Now, my lord, all these rules say
Clause
is,
6 makes things different, Mr. Mishra, in this case.
my lord,
Clause 6 has an indication of a
yes,
deemed
on
confirmation.
successful completion of
Its
the
only requirement is completion of the period
yes,
and passing of the exam. And then there is a confirmation
Yeah.
automatic. No specific order is required
but
as per this.
yes, yes. Now I'll come to 17. A person appointed to service at page 7 of the compilation, same compilation. A person appointed to the service shall be confirmed if the service, if he has completed his period of probation, if any, to the satisfaction of the governor. He has passed departmental examination and success only undergone and success, something wrong, only undergone the course of training prescribed for him, is considered otherwise fit for promotion by the governor, provided where number of service is not given, a member of service is not given opportunity to undergo prescribed survey and settlement training during the period his probation. His confirmation shall not be held up for the reason only of not having undergone such training, but such persons, when called upon by the governor, opportunity given successfully undergone such training. Provided further, the governor may, for good and sufficient reasons, temporarily exempt member of service from passing any one or more prescribed departmental examination and confirm him in the service. Now, my lord, I have no hesitation in admitting before her lordship that she did not pass any examination. That I had asked, and the answer was that.
So there was an examination provided for confirmation.
The second appellant, Pallavi Sharma, she completed, she cleared all the examination.
But this Sabira Imran,
Yes.
she did not undergo the examination.
No, when examination could be given, it can be things. So at that point of time, she had not cleared.
She had not cleared.
She had not cleared that. I have asked and then I got a specific answer that she has not cleared. But nevertheless, my only submission before your lordship will be, obviously there is no order of confirmation. There's no denying fact. The only thing to stick on is 3 situations before your lordship. One is the notification dated 15/9/2017, where is it you have completed
the period of
your probation. And then certain mandatory requirement to those things were exempted. And the second thing is that she was given even the second increment. And next was that an inquiry was contemplated. This I'm saying because a probationer is there. No inquiry is required. So this is, my lord, last to say on this is that confirmation is an inglorious uncertainty. My lord must have seen Justice Chandrachud, I will now say senior, Justice Chandrachud senior's judgment. That was a case, my lord, of direct recruit and promotee. It's question of seniority. That somebody says we were confirmed before him. So in that context, of course, it is said that confirmation is an inglorious uncertainty. So what I'm submitting before your lordship is, I've completed my probation. Even before these things happened. and I was exempted and I was given a regular posting. There is a provision for relaxing, or I could have been, I could be given an opportunity to pass the departmental examination later on also. It is not a sine qua non for confirmation. There is a power to relax for the time being. So therefore, in this view of the matter, since I have been allowed, well, it's not a case where I have completed the probation and there is no order. The order, of course, came. Because as I said, when Mr. Kohli came, he will ensure that no loopholes are left. So there was an order. And that order was passed 4 months after that 15-7 letter. I'll place that. You this. Okay? That order was passed on 18-1, and it is mentioned, very well, and it is mentioned in my lord their affidavit. The order was passed on my lord 20th January 2018, extending my non-existent probation.
Okay.
At page 144. Of the paper book, if possible, kindly take 144. The relevant is paragraph 40 at page 158. My lord got it. Page 158 of their affidavit in opposition.
158.
158. Paragraph 40. Without prejudice to aforesaid position of law, it is submitted that by another notification dated 20th January 2018, the period of probation was extended. The order is so and so. The said order has been passed in terms of 51 of Assam Police. So and so 15 all persons recruited to service quoted here shall accept person recruited under 5.2 be on probation for a period of 2 years from the date of appointment of service. Period of promotion may, for good and well, kindly note down. I'll take your lordship through the order. Good and sufficient reason be extended by governor in individual cases by such period as deemed necessary. This is the rule which they have quoted. Now I'll take your lordship to page 178. 178. This is the extension order. My lord got 178. Whereas Srimati Sabira Imran, APS officer, was appointed on probation to Assam Police Service Junior Grade by order dated 12/10/2015. Whereas an investigation by Dibrugarh Police is going on in the recruitment of APS and other allied services officers of 2015 batch, the government is not in a position to form a requisite satisfaction in respect of Sabira Imran, APS. Therefore, Sabira, the service of aforesaid pension is not proposed to be confirmed at this stage. And then please to extend the probation for another 2 years. My lord, this order was necessary. Of course, I could have, if I had filed the affidavit in reply, I could have questioned this order by saying that this was never served on me. And she is a gazetted officer. This has to be gazetified. Where is the gazette? And this, my lord,
Serial number 14.
Serial number
14 at bottom of this order.
Here, Deputy Director Assam, yes, I've seen that. My lord, whether it is published or not, that is material.
That issue, whether it was raised or not.
Absolutely. I said it in the beginning, my lord. I said in the beginning, I could have raised it, but it is not in the affidavit in opposition. I can't help it. Yes. But all said and done, my lord, what are the sufficient reason? This region, what would happen, my lord, to the period from 21/8, 2017 to 21, 2018? In between, there is a gap. My lord, according to me, this has been passed. Again, of course, it's not in the pleading. This, according to me, this has been passed that if I am a probationer, it will be easier for them to throw me out. There could not be any other reason because this has, we have not received it. This is first time we noticed in their affidavit in opposition. Because this should have come in our writ petition if it was there. Now, my lord, after
So,
that,
Mr. There is another way of looking at it. If you did not file any affidavit in reply,
yes. No, I filed.
disputing this document,
I filed.
disputing this document,
Yes, that.
then there is a suspicion that this document was concealed by the petitioner.
Unfortunately, all suspicions are on this side only.
That would be the natural consequence.
Yes.
Because you don't dispute it and then you raise an argument that we would have challenged it.
My lord, I
Carry
said this in the beginning.
Let's not go on that.
No, but did I not? My lord, I
You
will
said
not-
it very, very fairly. You said
I
it.
will not, my lord,
Yes.
try and conceal anything, my lord. What is there is there. So, my lord, my submission would be that there is no specific requirement under section 17 that an order is signed to a norm for confirmation. And the fact, the three regions, I'll not again repeat it. For those three regions, it will be assured, my lord, that I was confirmed. Now, the discharge order, because after this, I was discharged. And the discharge order was on 27/7/2018. My lord will get at page 135. Yes, no. No. 135.
One.
Governor of Assam, in exercise of its power conferred by 16B, is pleased to discharge Srimati so-and-so under suspension from service with immediate effect. Now, my lord, this and the order of suspension, if your lordship will see. If your lordship permit me, I said, was it a change of stand or they become wiser? Because they earlier tried, they earlier said that disciplinary proceeding is pending.
Not pending, contemplated.
Contemplated. That's one of the standard stipulation for a suspension order.
Suspension order.
Unless it is contemplated, one cannot be placed under suspension. So this is an innocuous order. It's discharge simpliciter. So this was fast. This was challenged, my lord, on two grounds. One I have already placed, my lord, before your lordship. And I have also placed paragraph 5, the finding of the court on it, and Chandra Prakash Shahi. But Chandra Prakash Shahi, one thing which I skip, or I can go now. My lord, if your lordship will take again page 48 of my compilation, page 48. I had placed, my lord, paragraph 9 and 10. 48. Paragraph, I have placed the rules quoted at paragraph 9 and 10. Now, I will, my lord, I relied on this for the proposition that is called out in paragraph 12 at page 56. Now it is well settled that a temporary government servant or a probationer are as much entitled to protection under Article 311(2) of the Constitution as the permanent employee, despite the fact that the temporary government servants have no right to hold the post and their services are liable to be terminated at any time by giving them a month's notice without assigning any reason, either in terms of the contract of service or under the relevant statutory rules, regulations, the terms and conditions of the service. The court, therefore, lifts the veil. That is different, but I'm saying only this for the proposition. Lifting of veil, I'll go later. Article 311 is also applicable to the probationers.
Probationers.
If there is the order
Allegation
of
of
dismissal
misconduct.
is passed on the basis of
Systematic allegations.
certain misconduct. And this will be the third case, Malad. The first, as I have said, 58 for Tamlal Dhingra, then 74. Samsher Singh. Will Lordship like to go through Samsher Singh's one?
We are not stopping you at,
No, I'm because
you can read
My
whatever
lord-
you want.
my lord, your lordship does it quickly, and your lordship. Therefore, I don't want to waste the time. So therefore, I asked. In the end.
Mr. Mishra, we didn't even stop you from reading every judgment in that criminal appeal. This is a service matter.
My lord, but
There is no question of stopping you.
my lord, because this,
We are treading on very different kind of territory in this case. Yes.
my lord, I'm sorry, paper book two, and he said, this Diana. Oh. 74 to whether we can get, I'm sorry, it should have been given. 74 to SCC.
74 to SCC.
My lord, this was also, I gave it to Mr. Kohli also, but it is not there. And 74 to. Pani Dodo. Oh, page is 831. Pilot may turn to paragraph 62. At page 850 of the book, SCC. The position of a probationer was considered by this court in Purushottam Lal Dhingra versus Union of India. Chief Justice last speaking for the court said that where a person is appointed to a permanent post in government service on probation, the termination of his service during or at the end of the period of probation will not ordinarily and by itself be a punishment, because the government so appointed has no right to continue. Government servant so appointed has no right to continue to hold such posts any more than the servant employed on probation by a private employer entitled to do so. Such termination does not operate as forfeiture of any right of a servant to hold the post, for he has no such right. Obviously, such termination cannot be dismissal, removal, or reduction in rank by way of punishment. There are, however, two important observations of Chief Justice Das in Dhingra's case. One is that if right exists under a contract or service, or a service rule, to terminate the service, the motive operating on the mind of the government is wholly irrelevant. The other is that if the termination of service is sought to be founded on misconduct, negligence, inefficiency, or disqualification, then it is a punishment and violates Article 311 of the Constitution. The reason why motive is being said to irrelevant is that unless that it inheres in the state of mind, which is not discernible. On the other hand, termination is founded on misconduct, it is objective and is manifest. No proposition can be laid down that where the service of a probationer are terminated without saying anything more in the order of termination than the service are terminated, it can never amount to punishment in the facts of circumstances of the case. If a probationer is discharged on the ground of misconduct or inefficiency or for similar reason, without a proper inquiry or without his getting reasonable opportunity of showing cause against his discharge, he may be given case in a given case amount to removal from service within the meaning of Article 311 of the Constitution. The other, according to me, may not be relevant. I'm citing this decision for the proposition that if service of a probationer is dispensed with on the ground of misconduct,
Misconduct, then inquiry.
then inquiry
311, protection of 311
yes,
is available.
is available. And my lord, this is by 7 judges bench. Purushottam Randhikara, the cost of repetition I'm saying was by a constitution bench.
Lordship, respectfully, sorry to disturb, but para 64 is something we had also relied upon. So I just thought
I'll just read it out.
Mr. Kohli, we have noted para 64. Don't worry. Already.
Let me also, my lord, I'll also, and I have also noted and I have marked, but I thought it is not. Before a probationer is confirmed, the authority concerned is under obligation to consider whether the work of probationer is satisfactory
Yes.
or whether he is suitable for the post. In absence of any rules governing the probationer in this respect, the authority may come to conclusion that on account of inadequacy for job or for any temperamental or other object not involving moral turpitude, the petitioner is unsuitable for job, hence must be discharged. No punishment is involved in this. The authority may in some cases be of the view that conduct of probationer may result in dismissal or removal on an inquiry. But in those cases, authority may not hold an inquiry and may simply discharge the probationer with a view to giving him a chance to make good in other walk of life without a stigma at the time of termination of probation. If on the other hand, if a probationer is faced with an inquiry on the charges of misconduct or inefficiency or corruption, and his services are terminated without following the provision of Article 311(2), he can claim protection. In Gopi Krishna Prasad versus Union of India, it was said that if the government proceeded against the probationer in the direct way without casting any aspersion in his honesty or competence, his discharge would have the effect of removal by way of punishment. Instead of taking easy course, the government chose more difficult one in starting proceeding against him and branding him as dishonest and incompetent officer. Any other paragraph Mr. Kohli will read, but this also, my lord, supports. And I said in the beginning, if my lord Chief Justice will remember, I said if an inquiry is only conducted to see whether I'm suitable for the post or not, I'm not to be given any opportunity, because this is just to find out whether I'm suitable for the job or not. But if there is an allegation of misconduct, fraud, or corruption, then there has to be an inquiry, and principles of natural justice has to be followed. Now, in the instant case, my lord may have come to know cases where a veil is lifted. Sometimes what happens, the foundation and motive of the order of termination is worded in simple word, without saying anything, without attributing any imputation, without any imputation. These are termination simpliciter. But fact is that this order is not a termination simpliciter, but it is camouflaged one. And therefore, my lord, in some judgment, your lordship says, in inappropriate cases, we can lift the veil and see whether this order is based on misconduct, foundation of the order is misconduct, or it is an order simpliciter. There are decisions, a number of decisions on the point, on the simpliciter. I'll place those decisions. But I'm not what surprises me is the averment that has been made in the affidavit in opposition. My lord, all kinds of plea has been taken there in a sense
Firstly, they say there was colossal fraud, unprecedented level. The entry into the service was by manipulation, not on my own merit. And having said that, so here you don't, Lordship, do not have to even lift the veil. They have come with the open face. There's no question of lifting a veil here. And then they say that this is an order simpliciter. They themselves say this is an order simpliciter, discharge simpliciter. It will not be any obstruction in getting another job. All these they have said. I'll place those paragraphs if your Lordship. So this is an admitted position that this is not a discharge simpliciter as it looks, as admitted by the respondent. I'll place, my lord, the finding of the first of, I'll place, my lord, the affidavit in opposition which they have filed. Your Lordship will, their affidavit in opposition starts with paragraph 144. And relevant paragraph will be 48, 51, and 77 of the affidavit in opposition. My lord will kindly go first to paragraph 48 at page 162. Lordship, got me, please.
Yes.
48. While the petitioner was serving on probation, the respondents filed notification dated 27/7/2018 in exercise of the power conferred under 16B of the Assam Police Service Rule 1966, discharged the petitioner from service with immediate effect. This is without prejudice to the submission that all the cases in the present batch of writ petitions are cases securing appointment to public office by fraud. And petitioners are not entitled to remain in those public offices, and all contention in relation to probation, protection of Article 311 and other principles of service law, etc., applicable only in cases where there is no question mark on the process of selection and securing appointment, are not at all available to the petitioner, and all the writ petition deserves to be dismissed by an order of the court. So, my lord, because of this, the distinction your Lordship will see they have made, that if the entry is okay and you are appointed as probationer, it's fine, you are entitled for 311 or principles of natural justice. But if your entry itself is bad, you are not. This is a new proposition of law.
It's not a new proposition.
My lord.
You place it on the same pedestal as cases wherein the applicant, while filing the application form, makes a concealment. In that case, there are n number of judgments which say no requirement of following principles of natural justice.
That
Almost on the same pedestal.
My lord, I'll place those judgments with my Lordship.
This is
what
what we mean to convey. There's nothing new about it. It may not, it may have been worded in that fashion to seem that it is a new thing.
But my lord, what I have seen cases where, for example, the caste certificate, persons have
Factum of conviction concealed. There's no requirement of natural justice there. So,
my lord, factum of conviction, that's something which doesn't require any inquiry.
So
it will be writ large.
They are coming with that theory that this is a pre-selection misconduct
Yes.
for which there is no requirement of 311. Because misconduct which is referred to in 311 is misconduct after joining service.
Now, my lord, then that brings to one question which with that, my lord, I think today I'll not be able to complete. With conversation, I get enriched, my lord. My lord, a hypothetical situation where a probationer is confirmed by a speaking order. Thereafter, it is revealed that his entry into the service was fraudulent.
Yes.
Can he be just thrown? I'm asking question to myself. Can he just be?
There was a case in Rajasthan
My lord.
wherein an employee who forged his date of birth certificates at the time of entry in service
Yeah.
was sent home after 25 years on this very ground,
Without notice.
without any
Without any-
inquiry. No notice was there, but no formal inquiry.
No, but my lord, formal
Just a notice.
inquiry, I'm saying, at least give me some chance to explain my conduct.
Yes.
If at all, these are my lord, all in the
That,
relevant.
that was a situation wherein the case was of a confirmed employee serving for 25 years.
My lord. No, I'll definitely find out that judgment.
Yes.
I'll surely find out that judgment. So I have to, my lord, look into the two things. Because, my lord, there cannot be any distinction that your entry into the service is on basis, not on merit, but on basis of fraud. If there is an allegation, at least some notice is required to be given. If I concede for a moment, my lord, that all right, 311 you go, at least give me an opportunity to explain. How can they say even notice you are not entitled? Now, there cannot be any distinction in respect of a probationer and a confirmed employee if the services are dispensed with on the ground of misconduct.
Does non-confirmation, action of non-confirmation
Yes,
warrant any show cause notice?
yes,
Does it? Under the rules?
my lord.
The government has decided not to confirm the service.
So that
of
is
the
different.
probationer.
That will be a different, government can discharge. Government can say that, look, we are not satisfied with you're not suitable for the post. We'll discharge you. That I've been saying from the beginning.
Okay.
Then that will be a different situation. But here there is an allegation on me.
Yes.
And my lord, the more important thing is, even if tomorrow I'm acquitted, I will not get back the job. Supreme Court has laid it down in Joginder Pal Singh case, which was yesterday placed before your lordship. My lord immediately pointed out paragraph 18 and 19, where this is your case, that tented one, case of tented one. And there in paragraph 20, my lord, a submission was made that some of the persons who have been acquitted. Supreme Court said, no, we will not go into. So kindly see the situation, even if we are acquitted and all the charges is held to be bad, will not get any benefit. We cannot come. At least in such a situation, we are entitled for notice. Hear us. Don't condemn us before hearing. Otherwise, tomorrow on a sub-inspector's report, you start throwing us out. Then I'll continue.
When should we now post them?
Monday.
Monday?
Monday.
All right. Hearing continues. List for further hearing on arguments remain inconclusive. List for further hearing on Monday.
Well, one matter, item 1 to 5, the state of Mizoram matter. So I think my learned friend has also come from Mizoram.
Yes, easy.
So you are there. Yes, I know. I know. So your lordship is hearing. I have to also argue in this KPC matter. So when your lordships.
Let Mr.
that's why
Joseph say. Let Mr. Joseph say.
So Joseph, when it is that's court is asking.
Tomorrow.
No, tomorrow.
Tomorrow it will not be taken up. It will not be possible. Now you will have to bear with us for a few days.
As long as possible, Lordship.
Now it will go after puja break.
That's what we also.
So the matters could not be taken up owing to paucity of time. List for hearing on 21st November. 21st November. Okay.
Yes.
Same prayer as you can item on 9, your lordship.
9 also.
Lordship is taking up tomorrow the APSC matter.
No, yeah, on Monday.
Yeah, on Monday.
Lordship, that judgment Lordship was mentioning to in Rajasthan, I was wondering if perhaps Lordship was referring, it's a case of 27 years of service, which was by a 3-judge. And that is actually a state of Kerala. Perhaps it was relied upon.
Maybe.
I'm so glad.
Quickly.